Good afternoon, everyone, and welcome to this episode of Tillicki and Gibbons 2022 Employment Law Forum webinar series entitled Exploring Complex Procedural Laws in Labor Disputes, Class Action and Arbitration. My name is Patanin Swanchanwat, an associate of the Dispute Resolution Department at Tillicki and Gibbons. I will be a speaker today, and I'm also joined by Kun Surasawati Jamesuwan, a former judge and a now counsel at the Dispute Resolution Department at Tillicki and Gibbons. It is now my privilege to kick off this webinar today. During today's session, we will discuss complex procedural law issues in labor disputes under Thai law. Kun Surasawati will discuss labor litigation aspect and the use of the complex concept of class action from the legal and the practical perspectives. I will then continue to discuss an overview of arbitration and its role in labor disputes and its place in labor disputes based on the Supreme Court precedent. And with that out of the way, I will now give the floor to Kun Surasawati.
Thank you, Kun Patanin. Good afternoon, everyone. Our session today is roughly divided into two main parts. One is about arbitration and the other is about class action, which I will begin with. This session is meant to provide you with a basic understanding of these two very complex procedural laws. And because not all of our listeners have legal or litigation background, we will keep it short and simple. This also means that our webinar cannot be used as a legal advice per se. For our management friends here, we would like to introduce you to this webinar starting from setting the scope for our discussion. Today, we are only going to discuss about labor disputes. Those could be raised from employment relationships that is based on an employment contract. We do not include other types of relationships to the table today, such as hire for work or those related to subcontracted work. So let's leave other types of disputes aside. The laws in relation to this topic includes contract law, in relation to employment agreement, and general civil law in relation to such contract. For other special act that includes Labor Protection Act, Labor Relations Act, Act on Establishment of Labor Courts and Labor Court Procedure, which I'm going to call it Labor Procedural Law after this, and the Civil Procedural Code. Examples of these labor disputes that usually resolved in labor courts are displayed here. The details of this slide will be further discussed in detail in our second portion of the webinar, but I just want to lay it here just to bring to your attention of the possible labor disputes that may arise between the parties. So we divided the content into two main parts. Those are class action and arbitration in relation to labor disputes. But before we dwell into those complex procedural laws, let us provide you with some basic understanding about resolving disputes for our non-legal background listeners. Kun Patanin, the floor is yours.
It is now my privilege to kick off this webinar today. During today's session, we will discuss complex procedural law issues in labor disputes under Thai law. Kun Surasawati will discuss labor litigation aspect and the use of the complex concept of class action from the legal and the practical perspectives. I will then continue to discuss an overview of arbitration and its role in labor disputes and its place in labor disputes based on the Supreme Court precedent. And with that out of the way, I will now give the floor to Kun Surasawati.
Thank you, Kun Patanin. Good afternoon, everyone. Our session today is roughly divided into two main parts. One is about arbitration and the other is about class action, which I will begin with. This session is meant to provide you with a basic understanding of these two very complex procedural laws. And because not all of our listeners have legal or litigation background, we will keep it short and simple. This also means that our webinar cannot be used as a legal advice per se. For our management friends here, we would like to introduce you to this webinar starting from setting the scope for our discussion. Today, we are only going to discuss about labor disputes. Those could be raised from employment relationships that is based on an employment contract. We do not include other types of relationships to the table today, such as hire for work or those related to subcontracted work. So let's leave other types of disputes aside. The laws in relation to this topic includes contract law, in relation to employment agreement, and general civil law in relation to such contract. For other special act that includes Labor Protection Act, Labor Relations Act, Act on Establishment of Labor Courts and Labor Court Procedure, which I'm going to call it Labor Procedural Law after this, and the Civil Procedural Code. Examples of these labor disputes that usually resolved in labor courts are displayed here. The details of this slide will be further discussed in detail in our second portion of the webinar, but I just want to lay it here just to bring to your attention of the possible labor disputes that may arise between the parties. So we divided the concept into two main parts. Those are class action and arbitration in relation to labor disputes. But before we dwell into those complex procedural laws, let us provide you with some basic understanding about resolving disputes for our non-legal background listeners. Kun Patanin, the floor is yours.
Thank you. Just to give everyone a basic understanding of how disputes can be resolved under Thai law. As some of us may already know that disputes can be resolved by a number of ways. But for today's discussion, we will discuss the four generic ways of how dispute can be resolved. First off, we have negotiation, which is when parties in a dispute agree to talk to find solutions to their problems without interference from a third party. Negotiation can take place before or after a case is brought to court. Negotiation is like the first and amongst easiest ways to resolve a dispute. Next up, we have mediation. Mediation is generally negotiation, but with the help from a neutral third party. Mediation plays an important role, especially in labor disputes, because when a labor claim is brought before a labor court, the Thai law on labor court procedures would generally require that the parties enter into a mediation first before any further proceedings can take place. And even if that mediation, if this first mediation fails and the case proceeds further to trial, the labor court still has the power to engage the parties into mediation at any time of the proceedings before rendering a judgment. And if the parties can come to agreement during negotiation or mediation, they can conclude a settlement agreement to resolve their dispute. If not, then the parties would have to consider other alternatives to resolve their disputes. Now we move on to a more formal dispute resolution method of arbitration, which is one of the key topics that we will discuss today. Arbitration is more formal than the first two methods in that arbitration is somewhat similar to going to court. And that is, there would be this panel of the people called arbitrators who would consider and make ruling in dispute brought before them. This ruling in arbitration is called an arbitral award, which is binding upon parties in a similar way that the court judgment does. There are also rules and procedures in arbitration that resemble the rules and under the procedural laws that apply when going to court. And lastly, we have this most the option that most people are familiar with, which is litigation or going to court. And if we talk specifically about labor disputes, there would also be other dispute resolution methods apart from these four methods that we just discussed. For example, in the event of a submission of a claim by an employee or an employer's side under the labor relations law, the law mandates that a negotiation between the employer and the employee side concerning that claim take place. And if that negotiation fails, which would result in a labor dispute in the sense of the labor relations law, the law provides specific dispute resolution methods of labor dispute arbitration or ruling by the labor relations committee, depending on the case. But as Kunsurasawati has mentioned earlier, that in today's webinar, we will focus on the last two methods of arbitration and litigation, Kunsurasawati will first discuss the litigation method and will elaborate on the labor court procedures in general and the use of the complex concept of class action in labor litigations, as well as explore the associated legal issues and practical aspects that should be noted. I will then continue to discuss the general overview of arbitration and its use in labor disputes, as well as relevant Supreme Court precedent on this issue. I will now give the floor back to Kunsurasawati for now.
Thank you, Khun Patanin. Yes, we will start with the extreme first, the very bottom, that one, litigation. Litigation is the most formal dispute resolution method. One must strictly comply with the rules of the game, which includes for the formality of going to the court, the way we have to suit up and wear the cloak and all of that. Under Thai law, labor disputes are usually litigated in a labor court, which is a specialized court for the matter. These courts generally operate by utilizing a special set of tools called the labor procedural law, the one that I just mentioned prior to this, Act on Establishment of Labor Courts and Labor Courts Procedure. Having said that, the general civil procedural law still can be used as long as it's not contradicting with the special tool there. So just to give a broad picture of what's going on here is that the civil procedural code is where you can find class action law, and the labor procedural law is where you can find another set of tools that I will mention later on, the parties representative. So the code is also a tool for the labor court to use. Class action can be found in section 222/1 to /49. So what is class action? Class action is a special procedure that could be initiated by a plaintiff, one plaintiff, and starts with a plaintiff submitting a request to the court, requesting that the court to permit him or her to be the named plaintiff of a class action procedure. And by way of granting that request would mean that this very plaintiff would be working on the case and on behalf of the class members. For example, Mr. A brought a product from a supermarket and found a defect that he thinks that other consumers or other people who bought the same product might face the same defect. So Mr. A wants to file a complaint against the manufacturer to claim damages or some. Now, because of the product he bought was mass produced, many people who could have bought the same products off the shelves could have the same defect. So Mr. A here doesn't not know any other buyers at all, but he claims that he's filing a complaint on behalf of those class members as well. So he files this request to the court along with his complaint, stating that he wants to be the named plaintiff, wants to act on behalf of the class, and so on and so forth. Now, will the court allow that? The court will have to take into the account of numerous things like numerosity, whether the class is so numerous that joinder of all members as a common case would create difficulties and inconvenience. And the fact to determine this would depend on the circumstances. Questions to be asked would range from whether it's practical for each member to file their case separately on one's own, what's the size of the class. Other factors that the court would take into consideration would involve a class geographical distribution, ease of identification and location of class members, knowledge, and the size of the claim, for instance. The rule of thumb here is whether class action is superior to other available methods according to the law. Now the second one is commonality, which is whether the claim, the question of law, or the fact is it common among all the class members? the court would ultimately see if it can determine that it can resolve the issue, which is centered to that matter in one stroke, basically with one judgment, can it cover all the class members' problems? Latter one is the typicality, the defenses, the claims, is it pretty much the same set across the class? And the last one that I would like to mention today is about adequacy of representation. The court will have to make sure that the named plaintiff will fairly and adequately protect the interests of the class. Now, it's not just the named plaintiff, of course, the named plaintiff will also have an attorney, and that attorney will also have to be evaluated by the court. So there are many things to be heard in court before rendering its order on this matter. The court will consider the requests for class action, also all the evidence being presented by both parties. So it's a full-on trial in its own on this particular matter. After the court have its say, it will order whether the case will be proceeded as a class action case or not. So you can see that this is a very powerful procedural tool, and it could affect others. I just want to note that the most powerful bit would be that if the court grants the case to be proceeded as a class action case, the later rendered judgment will affect all class members, and other members who are not yet plaintiff can claim, benefit from that judgment. And this class action is permitted even for labor disputes as well. And it's mentioned in the code. So that's one of the things that I would like to highlight for you. Now that is a tool identified in the code, which is a very different tool from the party representatives that I mentioned before now, that is indicated in the labor court procedural law. You can see that class action could be initiated by only one person, and that one person is the plaintiff. Others are not required to be present as a plaintiff in a class action case. Could, but not required. These people could be affected and benefit from the proceedings itself and later rendered judgment. All these key factors are different for the party's representative, which is prominent in the labor procedural law, which is in section 35. Under this labor court procedural law, the labor court can appoint a representative. Now that I'm going to mention about the later one, party's representative. Now, the labor court can appoint a representative for either the plaintiff or the defendant, not just the plaintiff like the class action one, where there are more than one party involved in the case. For examples, is that it's generally used when there is more than one employee who filed a complaint against an employer. It could be easier to proceed with the case with having one person talking to the court, basically. But before setting up a representative, the court usually combines the case all together as well. So that's the first step. And then the court will initiate or by the plaintiffs or defendants initiation, kickstart the representation process in court. Now, after that representative is set and appointed, whatever this representative act in court, including enter into a settlement agreement, compromise agreement, those plaintiffs or defendants who appointed this representative would be bound to those actions as well. In this regard, the parties can select their own representative. The court will not intervene in the selection. It's a completely different level of intervention compared to class action. Basically, parties representative that is mentioned here is pretty much a choice that a party would make on their own. So in these cases, usually the outcome of the case, the rendered judgment, would only bind the parties of the case. Non-parties are generally not included. So this is a big difference between this one and the class action. However, there is an exemption because this labor court has this special tool indicated in section 53, that the court may use this special power to make other employees, other people outside of the case benefit from the judgment as well. But this really rarely occurs. So in conclusion, that this special tool is similar to class action because it involves many people, more than one people in a case, but it's a different creature altogether. So in short, the key differences between the two are one, class action, the named plaintiff is the class representative, although other members are not plaintiffs. And it is initiated by this plaintiff, not by the court or defendant. Secondly is, you can see there, that's party's representative is more like elected one rather than being scrutinized by the court, if there is more than one representative, the court will have to inquire and look into the details before allowing the case to proceed as a class action case, and also whether the plaintiff and the named plaintiff and the attorney is capable of taking care of all those class members. Now, class action is usually beneficial or not to the class members, regardless of their involvement in the case, but especially the rendered judgment. But for the class action compared to the party's representative, the judgment in the latter is not going to be bound, generally not binding other parties outside of the case, unless and until that court exercises special power, which doesn't really happen very often. So this is to give you a picture of what can happen in a labor court, because now the question is whether class action can be used in labor courts. Under Thai law, there is no obvious prohibition of the procedural of class action in labor courts, nor has there been any Supreme Court judgment or non-appellate court decision directly on the matter. So class action in Thai labor court, I think, is possible. However, because the nature of the labor disputes in Thailand, it's usually limited to one establishment, one employer, or one factory, in a sense, or one province. So it is unlikely that the nature of the case could easily fit in to satisfy those prerequisites that I mentioned earlier. Also, because filing claims at the court, labor court, is made easy by the less complex procedural law. And also because the court judgments could have the effect to provide for other employees who are not parties. So the court may not see that class action is the superior tool or the appropriate tool for the dispute. Again, class action procedures add time and expenses to the parties. Among other issues, like the named plaintiff and attorney may not be interested in working on class action because the cost and the remuneration is very low. So it could be said that class action is less likely to occur or granted in Thai courts. So what I have explained here is class action or group parties in litigated cases. Now it's time to explore another procedural tool to resolve disputes, which is arbitration. Batanin, please, the floor is yours.
Thank you. So now we move on to another alternative dispute resolution that we just briefly discussed in the beginning of this presentation. And we will now move on to this method of arbitration in labor disputes. But just to give everyone an overview of what arbitration is. Generally speaking, arbitration is when parties agree to submit their dispute to the so-called arbitrators for their consideration and ruling, as I previously mentioned. This Thai law recognizes this concept and this general ideas in the Arbitration Act. As I mentioned earlier, that arbitration is somewhat formal and similar to going to court in that they have the similar procedural aspects, but there is a significant difference in that arbitration would allow parties to agree on the details and procedures to resolve their dispute. For example, in arbitration, parties can agree to on the persons to serve as the arbitrators, the place to conduct the arbitration, the language in which the arbitration would be conducted, the applicable law to which the arbitrators would apply to the case, the rules and manners of how the arbitration would be conducted, or even to adopt the ready to be used arbitration rules offered by arbitration institutes such as THAC or TAI or any other institutes out there. Furthermore, parties can also decide to use arbitration in or outside the court. And outside of court, arbitration is more common as an alternative means to resolve the dispute that I just mentioned earlier, instead of going to court. However, an arbitration can also take place when a case is already brought before a court and is pending in the court. This can be done by a joint petition by all parties to the court to submit all or a part of the disputes to arbitration. This, however, is still subject to the court's permission. And if the court agrees, the arbitration would render an arbitral award for that dispute brought before them. The court would then consider whether the award is contrary to the law, and if not, would then render a judgment in accordance with the arbitral award. Arbitration is arguably preferred as an alternative dispute resolution method in that it usually takes less amount of time compared to going to court. Arbitration also allows parties to design a number of aspects on how their case would be resolved that I just mentioned earlier, which made parties feel that they received the proceedings of their preference, which most of the time would end up with a more flexible or less complicated procedures than going to court. Arbitration, also regarded as is suitable for cases with complex or technical issues such as construction claim or other complicated claims, which would normally concern complex facts and require technical knowledge in that specific area. Arbitration's feature would come to play here as it would allow parties to appoint arbitrators that they believe have proper qualifications and background to decide their case and therefore are fit for their case. This would not be the case for litigation, though, as the judge's selection is completely beyond the party's knowledge, let alone rights. Arbitration is also trusted for its confidentiality nature, where all case information would be kept confidential and not accessible by the public, unlike litigation. And I mentioned earlier that arbitration is when parties agree to resolve their dispute by way of arbitration. This agreement is recognized by the Arbitration Act as an arbitration agreement. The term arbitration agreement is defined under this Arbitration Act, but just to summarize it for everyone, it refers to an agreement between parties to resolve all or part of their disputes, whether already existing or to exist in the future by way of arbitration. This arbitration agreement may take form of a clause under a contract or a separate contract that specifically discusses arbitration. The Arbitration Act also requires that an arbitration agreement be concluded and signed by all concerned parties unless this arbitration agreement can be found on the correspondence between the concerned parties in a manner acknowledged by law. And once we have an arbitration agreement that is concluded in accordance with the provisions of the law and a dispute arises, this dispute must generally be submitted to arbitration as agreed in the arbitration agreement. However, if a party submits the dispute to the court instead of arbitration as agreed, the Arbitration Act would allow the other party to raise this arbitration agreement as a way of defense to the court in order for the court to strike the case out so that the parties can proceed with arbitration as agreed in the arbitration agreement. The Arbitration Act, however, requires that this arbitration agreement must be raised to the court by the deadline of filing an answer to the complaint as the latest date. If the court considers that the arbitration agreement is not void and legally valid, the court would then enforce this arbitration agreement by way of striking the case out so that the parties can proceed with arbitration further. If, however, the arbitration agreement is not raised or is raised but not within the deadline provided under the law, the court would then continue to hear the case without striking the case out for arbitration. So, what types of claims can go to arbitration? There's really no direct answer to this because Thai law does not provide specifically which types of cases that could be brought to arbitration, but it is generally understood that cases that could be brought before arbitration would concern civil and commercial issues, such as disputes related to sales and purchase agreements, construction agreement, insurance agreement, and other civil and commercial agreements. But it is generally also generally understood that criminal cases are not subject to arbitration. There are also other cases that concern public order or good morals that would pose an issue whether these types of cases can be submitted to arbitration, and if done so, whether there would be any issue with respect to enforcement of any arbitral award rendered in those cases at issue. And here in labor disputes, as Kunsaraswati has discussed in the beginning, that we have today categorized labor disputes into two groups. The first type is the disputes that concern rights or duties under an employment contract, such as disputes over clauses concerning non-disclosure, non-solicitation, non-competition, and other benefits and welfare beyond the statutory minimum. And these disputes concerned rights and duties in the civil and commercial aspects and not related to labor laws, and therefore can generally be submitted to arbitration as it falls within the domain that could go to arbitration that I just discussed in the previous slide. On the other hand, we have another type of labor disputes, which is those that deal with the rights or duties under the labor laws. For example, those under the Labor Protection Act or the Labor Protection Law, which sets the minimum employment standards that employees and employers have to comply with. The Labor Protection Law concerns public order, meaning any agreement in contrary to the legal provisions in the manner that is not favorable to employees would be declared void. Disputes under labor protection law includes claims for severance pay, claims for wages, or payment in lieu of advance notice. There are also disputes under different types of labor laws, such as Labor Relations Act, which provides measures and requirements on how a negotiation must be conducted in the labor relations realm. And there is also the Act on the Establishment of Labor Courts and Labor Courts Procedure, or I would shorten it as Labor Court Act, which allows an employee to file a claim against an employer for claims for compensation for an unfair termination. It can be seen that these rights are the rights that employees have under labor laws, which relate to public order and good morals, and are at issue whether these could go to arbitration. So we have issues whether these types of claims can go to arbitration. And we will now take a look at the court's position on these types of claims when they are brought to court with the presence of an arbitration agreement. Before we begin with the case studies on the Supreme Court precedent on this issue, we already know that if a party files a claim with the court despite an arbitration agreement, we can raise the arbitration agreement to the court's knowledge in order for the strikeout order so that those disputes can go to arbitration as intended between the parties. However, I also previously noted that there are issues whether some of the labor disputes that deal with rights and duties under employment or labor laws which relate to public order can go to arbitration. So here we are going to look at the Supreme Court precedents on the court's position in the enforcement of an arbitration agreement in different types of labor disputes. This first case, as shown on screen here, deals with a claim for compensation for unfair termination. In summary, the defendant in this case, which was the employer, raised an arbitration agreement to the court for the strikeout order. However, the court ruled that the claim for compensation for unfair termination is the right under the Labor Courts Procedure Act that I mentioned earlier, and not a right under the employment contract. Therefore, the plaintiff, who was an employee at that time, was entitled to file the claim with the court without the need to submit it to the arbitration first. In the end, the court still continued to decide the case without striking the case out for arbitration. We can see from this case that the court would not enforce the arbitration clause or to strike the case out for a dispute or a claim regarding compensation for unfair termination if it is brought straight to the court. Next, we have a case that deals with a severance pay and payment in lieu of advance notice. In this case, the employer defendant raised an arbitration agreement to the court like in the previous case. In the court's ruling, the court reiterated that an employer's employment rights can generally be categorized into two groups. The first is those rights that are under the employment contract, and the other is those rights that are under the employment laws. In this case, though, the court interpreted the arbitration agreement to mean that the parties wished to resolve the disputes by arbitration, only the disputes that arise from their employment contract. However, the claims for severance pay and payment in lieu of advance notice are the rights under the Labor Protection Act, not under an employment contract. Therefore, the court ruled that the employee plaintiff was able to file the claim with the court without the need to go to arbitration first. In the end, the court still continued to decide the case without striking the case out for arbitration like in the previous case. We can also see from this case that the court would not enforce the arbitration clause or to strike the case out for a dispute or claim concerning a right under the Labor Protection Act. Now, we're now finally at the case where the labor court decided to enforce an arbitration agreement in a labor case now. In this case, the plaintiff requested for compensation for loss of income and other damages, including those from the employer's failure to pay severance pay and other benefits provided under the employment contract. It should be noted, though, that in this case, the plaintiff did not claim for severance pay itself or for compensation for unfair termination. The defendant, who was the employer in this case, raised the arbitration agreement to the court. In this case, the court enforced the arbitration agreement, saying that the arbitration agreement applies here. What makes this case different from the first two cases and potentially led to the court's decision in this manner is possibly because of the fact that the relief sought from the plaintiff in this case were entirely about benefits under the employment contract and were about claim for compensation for other aspects of termination that were not related to unfair termination. Therefore, these claims were entirely related to the rights under the employment contract, not without touching the employment or labor laws domain like in the first two cases. This is potentially why the court led to the decision to strike the case out, and so that the case can be heard by arbitration. So now that we have looked at the Supreme Court precedent on the court's position on the enforcement of an arbitration agreement in labor cases, we can see that if the disputes are entirely about a right or duty under an employment contract without relevance to the right or duty under the labor laws, the court would likely enforce an arbitration agreement by way of striking the case out, as we could see from the last case study. If, however, the dispute entails a right or duty under the labor laws, the court would likely retain the dispute to the court without striking the case out for arbitration, despite an arbitration agreement presented before them. There could be more than one issue at dispute in one case, in which case the court would treat each issue on that basis, meaning that there could be a case where the court decides to strike out just some of the issues for arbitration and retain the other issues before them. And in reality, if we look at the labor disputes that arise from the employment or labor laws, we would see that they mostly concern the amount of money that employers are obligated to make towards their employees. And due to this nature, this type of dispute, the dispute under the labor law, is most likely to be commenced by an employee. Here, it should be noted there is no court's filing fee for commencement of labor litigation, and there's also assistance available to plaintiff for filing a claim with a labor court. Whereas there would be a number of fees associated with filing a claim for arbitration. Based on these reasons, it is very likely that an employee seeking this type of claims would choose to go to court instead of going to arbitration. Besides, the labor court would likely accept this type of disputes for consideration without striking them out for arbitration anyway, as we can see from the case studies on the court's position towards these issues. This is why it is quite rare, if not unheard of, for an arbitration over this type of dispute, thereby leaving no room for use of arbitration in this type of cases in reality. However, arbitration is still a viable option worth for consideration for cases of complex issues or facts, or cases that require technical knowledge, as I previously mentioned. Labor disputes for which arbitration may shine include those concerning non-competition, non-disclosure agreements, where the knowledge and the sense of marketing or business beyond the laws are key to better understanding of the case. This is often the case for high-level employees with various benefits that are far beyond the minimum standards offered by the Thai labor law. That being said, though, the presence of an arbitration agreement does not necessarily mean that a case would have to go to arbitration, as already discussed. This is because a defendant would still have the right to choose whether to enforce or raise this arbitration agreement to the court. Despite the pros of arbitration, some defendant may feel that having to start with arbitration over again is time consuming, or that the enforcement of an arbitration award would have to be done through court anyway. So there are some of the factors that might cause the defendant to let the court continue with the case instead of asking the court to strike the case out. And that sums up the arbitration and is used in labor disputes from my part. So we are now moving to the Q&A for this session. Kusrosawati, do you have any notes to add further to that?
Yeah, thank you, Matanin. I think you explained half of my answer to our question here. Wonderful presentation, by the way. Our listener here ask, in general, how long on average will court proceedings take for employment disputes, and how long would arbitrations take? Now, let's clear this out before we go into the details. The court and arbitration process before and during COVID-19 is fairly different from each other. Let's say we're talking about in general. Before COVID-19, if we mark point A of being filing the complaint to the court or to TAI, I suppose, and to the point when the court renders its judgment or the arbitrator renders its award, the award. Now, it usually takes around 1 to 2 years for the court to finalize that process. And for TAI, they have this timeline, vague timeline, setting it at 180 days. So it can be more or less around that period of time, but it would also depend on the court's availability, the plaintiffs, the claimant, the defendants, and the respondents' availability, the dates, whether they can or cannot manage to work within that time frame. So it could be around 1 to 2 years in court and less than a year in TAI. Now, after COVID-19, the labor court's backlog is just, I think, so much that now our cases could take around 1 to 2.5 years in total to get the first, the court of first instance, the labor court's judgment rendered. Again, the backlog, it depends on the time of in question here. It could be better next year after this backlog, this big chunk of cases are taken care of. Also, what I would like to mention is that in arbitration, like Kun Patanin just mentioned, it even after the arbitrator has rendered that award, there's a question about bringing that award to enforce. That we must go by way of going to the court and request for the court to enforce that award for us. So that could probably take more time. At the end, it could be similar to filing a case in the labor court. However, this is just a very, in general, on average thingy that I'm mentioning here. It's not a defined time frame. So I think that's pretty much. Another thing is that in arbitration, it's the procedure is quite relaxed as compared to litigation, even though there are, like Kumpatanin mentioned, that there are procedural laws affecting the process in arbitration, but it's not as strict as in litigation itself, because both parties can agree to these sets of rules in arbitration by their own. Basically, if it's more relaxed, loosen up, so it could affect the time that the arbitrator actually used to during the process rendering that award. So that could also affect the time frame that I mentioned. Patanin, do you have anything to add on that?
Perhaps a question that I could answer in follow-up to that then. Some of us may have questions that if arbitration is recommended for which kind of situation or which type of employee or in which situation in general. For just to provide a brief and concise response to that, it should be noted that I mentioned in the presentation that arbitration may come to play in the labor context when it comes to employment of employees with a number or various types of benefits that are beyond the minimum standards offered by Thai law. This is usually the case for expat employees or foreign employees who most of the time are entitled to benefits from the Western perspective, despite their presence or their physical being in Thailand. So this concept of arbitration would help when a dispute arises over these benefits or welfare, because if the dispute goes to court, then like I mentioned that the judge's selection is not within our knowledge at all, let alone our decision to choose who would decide our case. But for arbitration, we would have an opportunity to decide who would be fit to decide the case, who we believe would have the proper sense of marketing or business to that would understand the claim that we are making or that we are defending in that specific case. So this is kind of an anticipation that both parties, whether employers or employees, have to note or bear in mind when considering whether an arbitration would be of their choice. But whether an arbitration is needed on a specific case I would have to say that it would be on a case-by-case basis, depending on the situation and the circumstances of each case that we will have to discuss and look at it carefully before deciding. Do you have any notes further on that?
Sure. Another beneficial character about arbitration that I would like to mention is that if the parties would like to keep the content of the process confidential, arbitration is a good choice as well, because we can keep the doors closed as compared as the labor court. The doors are open and to the public to sit in and basically view what the court is doing in the process. So if confidential, if you'd like to keep things like that, say if the dispute is about keeping information confidential in the company, and that there's a breach on that, pretty much that clause, yeah, I would recommend that if that is of a concern, arbitration is a better option as to litigation. Now, to mention the differences between those two, I would like to also mention another method of resolving this dispute, which is mediation. Mediation is still available. Negotiation is also still available in both arbitration process and litigation processes. Saying that, coming back to that first question there, is that, right, on average, it might take that X long, but if both parties could settle the dispute by way of concluding in a settlement agreement or compromise agreement, that period of time in the proceedings would be shortened down a lot. Like in Kun Patanin just mentioned in his presentation, that mediation is part of what the labor court does. And during usually the first hearings, the court will try to mediate the case. And I think most, if not all, most cases are mediated and successfully mediated by the court as well. So for those cases, the proceedings would be cut short to a few months, even not even half a year. But that would also depend on the nature of dispute and the what the parties think about the ongoing dispute. Is there any potential ways of concluding or resolving the disputes in that way or not? So even though you're already at court or in a process of arbitration, mediation, or concluding the disputes by way of, getting hold of it on our own, controlling of the outcome on our own by way of setting up an agreement with the counterpart, is still available.
Perhaps I should address one question then. Some of us may have questions about whether arbitration can be used to resolve disputes, to resolve the labor disputes in the sense of Labor Relations Act. We briefly talked about how the Labor Relations Act has its own kind of labor dispute, that the laws provide specific dispute resolution mechanisms for its own realm. So in this case, we have to see, we have to firstly note that the labor relations law do not clearly provide that arbitration can be used there. Also, although I noted in my previous presentation that I used the word labor arbitration, but that is a general sense of term that I used as a literal translation of the Thai text there. It's basically what I meant by the labor arbitration in the labor relations realm there is when the labor and the employer and the employee side cannot negotiate on a claim that either one of them submits, or to agree on on that claim, then the labor relations law provide that someone be appointed to make ruling for that, to resolve that dispute, or to resolve that dispute between the two sides. But that is not the arbitration in the sense that we discussed under the Arbitration Act, though, because that, in the sense of the Labor Relations Act, it is the specific method offered by the labor relations law, which is not related in any way to an arbitration under the Arbitration Act. So we just have to make that clear. And the same goes for other types of labor disputes under the Labor Relations Act, or any other, or some other channels of ways or claims under the Labor Relations Act. For example, going to asking for the court's permission to terminate an employee committee. That is this concept. There is a root for this concept provided specifically under the Thai labor relations law, and that is going to court. We do not have the concept of going to arbitration for that. So we just have to separate between what the specific ways are provided under the labor laws and the general ways to resolve the dispute. So,
Yes.
Consuelo, do you have any?
Yeah, of course. When it comes to Labor Protection Act, Labor Relations Act, those things, when they're just like as compared to my presentation on the general rule and the exceptions, right? There are areas that the law provides a specific tool for that kind of matter or dispute resolution, and usually the exception will prevail in some circumstances. So when we think about it, whether we are going to include an arbitration clause to the contract or not, do discuss with your lawyers, because those clauses can be designed in a way that you can divide the potential disputes to be resolved by arbitration. It doesn't need to be all of the disputes under the contract, things like that. But also, you can also design how in those clauses, you can also design how you would like the arbitration procedure to be. So those clauses can be short or long, depending on how you would like that dispute method to be in the future. And by way of designing that in your contract well enough, you will get, well, basically the clause would be enforceable if it's well written, right? So there are concerns that Patanin already mentioned in his presentation, but to choose whether arbitration is the right method or not, what I'm informing you now is that that particular procedure can be designed tailor-made to your needs, such as the number of arbitrators that you'd like to appoint. You can even also include the name of the arbitrator that both parties would like to use to appoint in the future. You can select the institute that you'd like to be the office that will take care of that administrative bit of arbitration, like TAI or THAC in Thailand. And for the rules, even though you choose either of the both, you can choose a different set of rules like the ICC for your dispute. But all of that, you'll have to go through a number of things that you'd like to make possible in the future. Now, one of those things about arbitration that we haven't discussed is that you can also say where you would like those process be held at. It's very flexible. Numbers of arbitrator, where would you like the proceeding to be, how would you like to be contacted, how many people would like to be included in the meetings with the arbitrator. Also in arbitration, you can hire other nationalities to be arbitrator to the arbitrator and your representative in the procedure as well. So it's quite open to numerous different kind of procedure altogether. So you can be creative, but in doing so, you'll have to have some guidance into how you would like to craft your agreement. So that's pretty much what we have to say for arbitration and labor disputes, and also for class action for this session. Khun Patanin, do you have anything on our Q&A left unanswered?
Let me scroll down to see. There's also a question about class arbitration as well.
Mm.
If the concept of class arbitration, though, I can, maybe you could, so somebody can elaborate further on that then, but the concept of class arbitration is admittedly not described under the Arbitration Act, to be honest. We can see this concept from the Western jurisdictions apparently, but this concept, however, doesn't appear as statutory requirements or procedures under the Arbitration Act. But one thing that we should note though is that this concept used to appear in the rules offered by TAI. However, this has been repealed by the amendments of the TAI rules, the previous one, the most recent one. So this concept is still not common, if not unheard of under the Thai jurisdiction of the arbitration, let's say that. But apparently we do have the class action for litigation, but less so on the arbitration aspect. So
Right. So for class actions case, I think
that's it for today's presentation and this year's annual employment law forum. Thank you everyone in attendance for today's session. If you have any remaining questions or if you have any further inquiries regarding this session or any other sessions, please feel free to email our speakers directly or at Dillicky and Gibbons. And thank you everyone for attending this session today and this year's annual employment law forum.